Good morning, my name is Lydia Barrena and I'm the head of the Labor and Employment Law Department at UHY Fay Co. The most common mistake is to view the equality plan as a mere formality, a document that once obtained is filed away and our obligation is fulfilled. But this is not the case. It is a living tool. The equality plan contains specific measures to correct the inequalities detected. If these measures are not then implemented or follow up, the plan will lack effectiveness and validity. Current regulations expressly establish the obligation to carry out at least 2 evaluations, 1 intermediate and 1 final. In addition, the plan must be reviewed in specific circumstances such as substantial changes in the company or if required by the Labor Inspectorate. The obligation to have an equality plan applies to companies with 50 or more employees, but not only to that companies, also to those companies that not reaching this threshold are obliged to it by the collective bargaining agreement or those which is imposed by the Labor Inspectorate. Another common mistake is not to calculate correctly the staff in order to determine if the company needs or is obliged to have an equality plan. In order to do the right calculations, we need to count all staff, disregard of the employment contract they have. So we need to take into account fixed contract, fixed-term contracts, part-time contracts, and even employees rendering services from a temporary employment agency. And not only that, also has to be taken into account the temporary contracts terminated in the last 6 months, counting 1 more person per 100 days worked. The calculation has to be at least made twice a year, one at the end of June and one the last day of December. And it is important, once the company reaches the 50 employees, this obligation remains even if the staff is later reviewed. Thinking that the equality plan is optional to be registered is a huge mistake. All equality plans need to be registered, and even those that are adopted voluntarily. Failure to comply with the equality plan may constitute a severe or very severe infringement and may result in sanctions, penalties, very serious. But not only that, also accessory penalties like losing deductions or benefits arising from the employment programs, or the exclusion to participate in these benefits for up to 2 years. And more important, the impossibility to hire or to make any contract with the public administration if the company does not have a registered equality plan. A good equality plan improves motivation and reduces staff turnover, and is also a very good instrument for employer branding. It's also very important for the image of the company and its reputation.